The following is paid advertisement and does not reflect the opinions of this station. The choice of a lawyer is an important decision and should not be based solely on advertisements. The information presented in this program is general and is not intended to be legal advice and should not be relied upon or used without consulting a lawyer to consider your specific circumstances.
Questions about law, stories from the courtroom, cases that might impact your life. It's time for Tell Me I Have a Case with Dan Grimm and Matt Glenn from Cook, Barquette, Ponder, and Wolves. Find them at cbpw-law.com. Here's Dan Grimm and Matt Glenn.
Good morning and welcome back to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. I'm Matt Glenn. Dan Grimm has, well, I'm not going to sugarcoat it. He's flown out to Las Vegas for a continuing legal education seminar, which I'm sure is broadening his ability to represent injured clients all over southeastern Missouri. He's out there with Mike Ponder, and so mining the store is myself and Matt Davis, who is one of our lawyers at Cook, Barquette, Ponder, and Wolves. Matt, say hello to the folks.
How you doing, folks? Good to be here.
Hey, don't call him the best color man in the game for nothing. Anyway, we are going to be talking today about the appellate process and the law's impact on personal injury litigation. One of the things that separates our law firm from other firms that do our type of litigation is we have two lawyers who are pretty much dedicated to making sure our case complies with the law. It is one thing to get $1 million verdict. It's another thing to collect it. Anytime you get a verdict that's of any significant size, the defendant has a huge incentive to try to appeal that verdict. And we have two lawyers, Matt Davis and Kathy Wolves, who are in our office to basically make sure that we follow the law, that we check every box that we need to, so that not only do we get the verdict for our client, but we're able to collect it. So, Matt, you grew up in Cape Girardeau. Tell the folks a little bit about yourself.
Yeah, sure, Matt. So, born and raised in Cape Girardeau, went to St. Vincent de Paul's Elementary School, went to Notre Dame High School, and then after that I went to Mizzou for undergrad. I studied biology out there. Ended up going to law school. I've got some lawyers in the family, namely my dad. We can maybe talk about that a bit later, but
well,
yeah.
let's do it right now.
Okay.
Your dad is who is your dad?
My dad's Pat Davis. He's been a lawyer in this area since, probably late 80s, I'd have to say.
And he's what you call a sole practitioner, right?
Yes, he is. Yeah, he's got his own office. It's just him out here. He used to, I believe, work at Bradshaw Steel and made partner out there, then opened up his own shop and has been working there ever since.
And what type of law does he practice? What sort of cases does he handle?
Yeah, so he does a wide variety of stuff, and that's one of the things I admire about him and that kind of got me interested in the law. He does stuff ranging from personal injury to criminal defense, probate, estate stuff. I mean, you name it, he probably does it. So he's quite a resourceful and sharp guy and does a lot of stuff out there. Yeah,
this is the Sons of Lawyer edition on Tell Me I Have a Case. You're looking at two people who have a stunning lack of creativity when it comes to choosing a profession. My mom is a lawyer, and I haven't told this story on the show. My mom was a partner in the 1980s at a really large southern law firm in Columbia, South Carolina. And the story goes that she got some bad news in one of her cases. And so she went storming down the hall with a string of obscenities coming out of her mouth that would have made a sailor blush. I mean, the air was absolutely blue. And there's an 80-some-odd-year-old couple that you got to think at this point, they would have been born around 1900 and raised in the Old South. And they hear my mama storming down the hall with these cuss words coming out of her mouth. That this is just not how women talk in Columbia, South Carolina in the 1980s. And this old woman turns to the lawyer she's there to see and struggles for something to say. But God love her, she comes up with the perfect response. And she says to her lawyer, "Well, I wonder what her husband must sound like." And the lawyer didn't miss a beat and said, "About my dad, oh, heck, her husband's a Presbyterian minister." So I don't know if I'm a son of a preacher man or a son of a something else, but on my best day, I like to think I'm both. So you graduated law school when?
That would have been 2017.
Okay.
Yeah, 2017.
And first job out of law school was where?
First job was clerking at the Missouri Supreme Court. I did pretty darn well in law school, but well enough to get to clerk at the Supreme Court, and I clerked for a judge by the name of Judge Paul Wilson, and he's currently the Chief Justice of the state of Missouri and runs some of the administrative stuff up there at the court, and it was a great experience.
Yeah, so tell the folks about that experience. What sort of matters are you working on when you're on the Supreme Court?
Yeah, so when you're up there at the court as a clerk at least, what you're doing is helping the court decide what types of cases to take. So the Missouri Supreme Court usually has some discretion to figure out what types of cases they want to take. They'll focus on stuff that's big, that's important. It's stuff involving constitutional rights like the freedom of speech, freedom of religion. It could be guns. It could be, a variety of important constitutional rights. So they usually take cases like that. And then it could be stuff affecting the public generally. So just a wide variety of stuff, really.
Well, and they also will take, complex litigation disputes
for
between
sure.
businesses and between people and businesses. I've heard it said that when you get to that level, you're not as concerned about the two parties in front of you, but your concerns are more broad.
Oh, absolutely. Yeah, the court at that level, what they really focus on is making sure that they get the result in a case that will help guide other cases. They want to make sure that they lay down some rule that is generally applicable across the board and that will do the best for the people of Missouri.
Yeah, and that way a business knows, how they can avoid being sued.
Right. Clarify the law and make sure it's a good rule so that it helps people in the future. Exactly.
And we use that law at the trial court. Those are kind of our guidelines in terms of how to get a case in front of a jury.
Absolutely, yeah.
So when you're on the Supreme Court, you got any old cases that stand out for you?
One of the ones that we frequently talked about is the old drum case. I don't know if anybody out there listening is aware of it, but Missouri is somewhat famous for this case. It involves a dog that was owned by a good old farmer back in the old days and got into a dispute with his neighbor, and his neighbor ended up, unfortunately, shooting this dog that kept going into his property. And the owner of the dog, as you might imagine, wasn't too happy. He ended up suing his neighbor and won a bunch of money. And in the trial court, which is, where you're working in front of a jury and you're trying to make your case, he delivered this very, very eloquent speech. And the lawyer was a guy by the name of George Graham Vest, and he was actually a senator of the state of Missouri at that time. And so he delivered this famous speech, basically a eulogy for this dog. It was reprinted in, I think, the Annals of Congress because it was so darn good. And the case ended up going up to the Supreme Court, and they affirmed a big award in favor of this guy who lost his dog. And
Wow.
So we have a statue out there in the court where kids can walk through, and anybody can walk through and see it. It's got this dog's head on it, old drum.
Geez.
And then they have Old Drum Day, I think, out in, what is it, Warren?
Warren, Missouri?
Yeah, I think so. Yeah.
I think that's where that case came from. Yeah, that's an area of the law I didn't even know about until you told me that story, that you can actually file a lawsuit over if somebody were to harm or, kill your pet. That was a new one on me. I didn't realize that was a...
And you hate to hear about it, but as a dog owner, somebody who loves animals, I'm sure animal owners just hear that and say, good.
Absolutely.
Yeah.
So when a case gets up to the appellate level at the Supreme Court, walk us through how it's presented to the judges.
Sure. So every case will usually start out at the Supreme Court level with an opening brief, right? It's the party that says the judge below got it wrong, right? They'll file a brief. They'll give all the legal reasons they think somebody's wrong. Then the other side gets to turn around and say, hey, judges, you just heard what they had to say. You shouldn't listen to them. The judgment below is correct. There's no need for you to intervene here and upset this judgment, give them what they want. You should listen to us. Then the other side gets to turn around again and file a reply brief, right? Saying, hey, you just heard why they disagree with us. Set that aside. You should give judgment in our favor in reverse. Then once those briefs are filed, the court will have a brief period where they get to kind of review the materials. They're clerks, so guys like me when I was working out there, they'll review everything. They'll look at the case law. They'll look at all the materials they've got. They'll report to the judges, kind of give them an update, an outline of what's going on. Then everybody comes before the judges on a scheduled date, and they'll argue, and each side gets about 15 minutes. Then right after that period, what the judges do is they'll hop off the bench. They're done hearing argument, and they'll usually cast votes initially, right? So they'll say, all right, we think 4-3, this side should win, this side should lose. Then they assign the opinion to one of the judges' chambers. That opinion will usually be drafted by a clerk, so it'd be somebody like me when I was working there. You then send the opinion to your judge. The judge will look it over, make any edits, do whatever they want to do with it. They'll circulate it, and then the judges will vote on it, and then that process kind of works from there. If everybody agrees, sticks to their original position, they'll go ahead and issue out the opinion once it's all finalized and taken care of. Or there could be some internal debate and things could switch around, but generally that's how that works up there.
Yeah. All right, and so I've heard it said the briefs, that really is where you win or lose these things.
Yeah, totally. Briefs, I think Justice Scalia coined this turn of phrase, but I think he and several other appellate judges said something to the effect of, about 99% of cases are won on the briefs, and it's a very, very rare case where the advocates will show up and argue for their clients and actually make a material difference at oral argument. There are those cases, but it's very rare.
Well, if you've got a good point to make, you're going to make it in your brief.
Right,
You're rarely going to save your best for the argument. It sounds like a very sort of intellectual exercise. One that obviously you got to be a pretty smart person to go through. And I imagine that one of the areas that that gets in front of an appellate court a lot deal with insurance policies. And that's something we deal with a lot in our office. We deal with, everyone out there probably has a auto insurance policy or a homeowner's insurance policy that they may want to make a claim against. A lot of times, the language of that policy is really important. In terms of insurance policy, the Court of Appeals has hammered out a certain set of rules. Basically, what are those rules in terms of construction of contracts?
Yeah, sure. So for all the folks listening at home or in the car, wherever you are, whenever you walk up to a lawyer, let's say you got an insurance dispute, they are going to have a set of rules that will dictate what your policy means, whether you get coverage, whether an exclusion applies, all that stuff. And basically the golden rule of this is that the court's going to try to interpret it from the perspective of somebody who's buying that insurance, right? An insurance policy is bought, obviously, to provide coverage. People get it in case an accident happens, and the court's going to bear that in mind. And then there are a whole host of kind of subsidiary rules that help a court figure out what this policy would mean just to the average person who buys it, right? That's the overall standard. And then there are a lot of subsidiary rules. I don't know if we want to go into those, but...
Well, I think one of the bigger ones, the importance of who drafted that policy.
Right. Yeah, definitely. And that's a good point. So frequently in a lot of these cases involving insurance policies, as I'm sure everybody's aware, insurance policies are quite fond of giving coverage, saying, hey, we'll cover you in this scenario. And then they'll say, buried down somewhere else in the policy, hey, except in these scenarios, right? It can get kind of tricky, a little bit unclear. And one of the important rules that courts will frequently bring up is the insurers are the ones who draft these things. They're the ones who prepare them. They're responsible for the language in there. And if something's unclear, since they're so much more responsible for the language and they're experts in this area, what courts will often do is say, hey, we're going to construe this unclear language in favor of the insured, the person who bought this and could expect some coverage, instead of in favor of the insurer who's responsible for this lack of clarity.
And one of the things I'm always hearing from you and from Kathy anytime I have one of these type of disputes is, well, give me the policy. Read the policy, because that language usually dictates. You've been listening to Matt Glenn and Matt Davis talk about the law's impact on personal injury litigation. That does it for segment 1. We'll be back in a few moments with segment 2 of Tell Me I Have a Case.
Cook, Barquette, Ponder, and Walls are very proud of the results they obtain for their clients, but you should know that past results afford no guarantee of future results, that every case is different and must be judged on its own merits, and that the choice of a lawyer is an important decision and should not be based solely on advertisements. And now, back to Tell Me I Have a Case with Dan Grimm and Matt Glenn.
And welcome back to segment 2 of Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. I'm Matt Glenn. This week we have Matt Davis, a lawyer from our office, sitting in for Dan Grimm, who's on assignment. You can contact the show at 573-708-7105. Leave us a message. We'll get your questions on the air. And today we are talking about the law's impact on personal injury litigation. And Matt, along with Kathy Woles in our office, it's their job to make sure that we can get your case in front of a jury. And to do that, it can be quite complicated. One of the things we always hear as injury lawyers is that people hate frivolous lawsuits. And I don't think anybody hates frivolous lawsuits more than people who do what we do, because the frivolous lawsuits kind of give us a bad name. But the law has ways of taking care of frivolous lawsuits. We're going to talk about some frivolous lawsuits next week. We're actually going to tackle the McDonald's hot coffee case. So that's a teaser. You're going to want to tune in for that. But in terms of the laws sort of setting up guardrails and kind of disposing of frivolous lawsuits, What how many opportunities does a defendant have if they get sued and they feel like it's a frivolous case to sort of get rid of it?
Yeah, that's a great question, Matt. A defendant in most cases will have at least 5 or 6 opportunities if they really want to take them all to get a case that they think is frivolous out of court. I'll give everybody at home an example. Let's say you get in a car crash, somebody hits you on the roadway, we file a lawsuit for you. As soon as we file a lawsuit, the defendant, let's say it's the other driver or maybe somebody else who's involved, they're allowed to say, hey, judge, I don't think that their allegations should be credited and that they entitle them to prevail. They can try to toss your case out that way.
And what's the procedure for that?
Well, the procedure for that would be they file a motion to dismiss or they file an answer and maybe some other form of pleading that basically tells the judge, hey, their allegations, even if you accept them, you got to toss out their case. They're not enough. Or, hey, there's some independent allegations I'm going to make that ought to require you to rule in my favor right now, just once this lawsuit's filed because of some defense I think I have.
So just as a matter of law, they can't make their claim.
Right. And that's right off the bat, before we even get into any discovery about the claims at hand.
Right.
In the lawsuit.
All right, so that's opportunity number one. Let's say they don't take that opportunity, or let's say we can get past that opportunity. Usually, we talked about earlier in one of our shows, that means you go into written discovery, you exchange information. Through the litigation process, you're really not allowed to shock the other side. If they ask you questions about your case, you have to provide answers to them so that they can prepare their best defense, and we get to do the same thing with the defendant. But a lot of times, a lot of facts emerge, and that can lead to another opportunity for the defense.
Absolutely. And we see this in a lot of cases, and this is one of the things I help out while at the firm. A defendant can do what's called filing a motion for summary judgment, and that's just a fancy way of them basically telling a judge, hey, Your Honor, you shouldn't even let this case get to a jury because we don't think they've got enough evidence for any reasonable jury to even find in their favor. They then, as a result of that, if they file that type of motion, it puts the burden on us to get in front of a judge and file something and say, hey, judge, look at all the evidence we've got. You ought to look at all this evidence, and this confirms that we've got a good enough case to get in front of a jury and to have a reasonable jury find in favor of our client. So that's one other hurdle we've got to get before we even get to trial.
And when you say evidence, it's not just us standing up in court saying, hey, this is what this witness is going to say. We have to get sworn testimony from that witness.
Absolutely, yeah. It's not just us doing attorney argument in front of the judge. You know, we're looking at written discovery, so it's stuff under oath. It could be a deposition where somebody's hauled out to some law office or some other location, put under oath, and they got to give sworn testimony that's admissible in court later. Right. We have to produce real evidence that would be used in a court of law and put that in front of the judge and say, you ought to let us get to trial on this.
Yeah. It's about, does the evidence support all the elements of a claim? Like negligence has several elements. You have to have a duty, you have to have a responsibility on behalf of the defendant to do something, to keep your parking lot free of hazards, to keep your floor at your grocery store free from water. Then you have to have a breach of that duty, and there's a standard, then a legal standard for that breach, and then that breach has to cause or contribute to cause injury to our client. If we don't check every box, we're not getting past summary judgment.
That's right. And we've got to deduce enough evidence on each one of those elements for a judge to say, all right, this is good enough for you to get in front of a jury.
Right. So if you're talking about a frivolous claim, a claim that that really has no merit, at that point it's going to be really hard to get past that phase.
Right, because the judge could look at the evidence, and if the evidence is uncontradicted, the plaintiff, the person who filed the lawsuit, let's say it's frivolous, if they can't produce any evidence supporting their account of what's going on, and it's just not plausible, and that's literally the standard. The standard at summary judgment is whether the evidence shows different plausible accounts. Right. If they can't show a plausible account of their side of what happened, the judge can just toss that case out of court.
When I used to defend these cases, one of the types of claims that was really ripe for summary judgment were the premises cases that dealt with third-party criminal liability, and that the plaintiff, you can actually file a suit against a store owner if you're the victim of a crime at that store under certain circumstances. But you have to have evidence that the store knew or really should have known that there can be criminal activity at their store, and that then they need to provide some type of security in order to, prevent that type of crime. Well, if you've got a store where there's never been a crime in the history of your store, and there's absolutely it's not in a high crime area, and maybe you're in a shopping center and there's never been a crime beyond simple shoplifting in that shopping center, you're not going to get past summary judgment.
Right.
You're not going to have that element of a crime.
Right. And I don't like the procedure, but it is fair, and it does weed out frivolous lawsuits, right?
Yeah,
it really does, and it's the whole frivolous lawsuit phenomena doesn't really apply to a lot of the cases we see out here. Most of the stuff, in my opinion, that a lot of folks see in the news would be class action lawsuits where somebody sues Whole Foods because the organic oat milk
is not organic.
Yes. Right? Stuff like that.
It's not organic, it's not oat, and it's not milk.
Right.
You do see and you do hear about a lot of those. But, if we get to summary judgment in a case, that means we've hired an expert. We've hired probably a doctor. We've taken some depositions. We're probably $20,000 into this case that we've spent, not to mention our time, litigating it. We don't do that unless, we believe we're going to be able to get the case in front of a jury.
Right. And the point you brought up about the expert, too. Yeah, you go out, you get your expert, paying them, to take part in the case. And we've definitely had expert eyes on what's been going on. And frequently that will factor into summary judgment stuff.
Almost every time. And our experts, people think, you pay an expert, he'll say anything. We don't have enough cases to pay an expert, a full year's salary. Right? These experts live and die on their credibility, and they're not willing to come to us and say, things that simply aren't supported by science, simply so we can pay them $2,000, $5,000. They're looking at the broader picture, and their credibility leads to their income for the full year, not just off one case. And it's why when a case comes in, one of the first things we do is we'll talk about it in our firm meetings. And I can't tell you how many times we've had a case come in and Matt and Kathy are over there in the corner going, you're not going to get past summary judgment on this unless you've got evidence of X, Y, and Z. And a lot of times that gets us to say no to a lot of cases. It's
one of those pitfalls. And you brought up the thing about all the various pitfalls, and I think we've only hit two, but yeah, there are certainly others which do kind of get me worked up about the idea that there are lots of frivolous lawsuits floating around, at least in this neck of the woods.
Right.
I don't think that's a fair assessment.
No, the jury pool down here is fairly suspect of litigation, and they're not shy about telling us at trial that our case isn't what we thought it was. All right, so we get past summary judgment. What's the next opportunity?
Yeah, so the next opportunity would be at trial, right? So you show up at trial, you get to put on your case. If you're the injured party, you're the plaintiff, you're putting on your evidence. At the moment you rest and say, you know what, I've called all the I've called all the witnesses I want to call. I've produced all the evidence I want to produce. The defendant, the other party, gets to say, hey, judge, they just rested. They're not putting on any more evidence. I don't think what they've put in the record and showed the jury is enough for any reasonable jury to give judgment in their favor. Mm-hmm. And so they get another crack at that. And it's similar to summary judgment. It's basically the same standard, but they get another crack at telling the judge, hey, judge, you ought to toss their case out and not even let this case proceed to a real verdict because they don't have enough evidence.
Yeah, and a lot of times the evidence or the testimony that might get you past summary judgment might be objected to at trial. It may not come in. Mm-hmm. So you may not have the same evidence once you get to directed verdict. You may not have met your burden, and the judge can toss you. Assuming they don't, then what's the opportunity after that?
Yes, so assuming they don't, the defense then gets to put on whatever evidence they want. They get to call their witnesses, do whatever. Jury gets to go back and deliberate. During that process, again, they get to say, hey, at the close of all the evidence, we don't think that the evidence is enough to let a reasonable jury, again, decide in their favor. So the judge gets another crack at that. Mm-hmm. And he can grant it, take the case away from the jury, or deny it, and let the jury go back and deliberate.
Okay. So the jury deliberates, and let's say that the defendant loses. After that, what's the next step?
So if the defendant loses, then the defendant has another crack at it. What they can do after the jury returns a verdict is say, hey, judge, you know what? Notwithstanding what the jury found, even though the jury ruled against us here, found for the plaintiff, again, we repeat, we don't believe that the evidence was enough to let any reasonable jury find in their favor. So we're going to request either judgment in our favor, notwithstanding what the jury said, or we're going to ask you for a new trial. So that's, I think, the fifth now opportunity that they get at the trial court level to say, hey, you ought to grant judgment to us.
Yeah, and I having worked with a lot of judges over my career, one thing they don't enjoy is being told by the Court of Appeals that they got something wrong.
Oh, not at all.
Yeah, they call them nasty grams in some cases. They don't want to hear. Well, I mean, nobody wants to be told by a colleague that, hey, you messed this up.
Right, it's something you're supposed to be good at.
Right.
You're supposed to know the law. You're supposed to understand how the evidence affects a jury.
Exactly. Yeah. And so you'll see judges a lot of time they get that motion for new trial that has to be filed within 30 days of the verdict, and then the judge has an additional 90 days to hear it. They're really looking at, did I get the law right when I made this call? Mm-hmm. And if they think they didn't, then they'll grant the motion for a new trial, and you're right back to square one.
Yep. Yeah, they may be reluctant. Obviously a jury verdict will bear on them a little bit, but there can be legal issues that aren't of the type of issue that are going to be resolved by the jury, where they might have some pause, and you may not be out of the woods just yet, even if you're a plaintiff standing there with a jury verdict.
We've had some really complicated cases against some really large, defendants, where the legal issues just aren't clear. I mean, we have guidance from the Court of Appeals, but sometimes something comes up that's unique, and the judge has to make the best call they can, but there's no guarantee then that they're going to be upheld. All right, they deny the motion for a new trial. What's the step after that?
Yeah, so I think, again, after the 5 little points we just talked about where the judge can either give you the thumbs up or shoot your case down, let's assume you win at the trial court. The defendant then has the right to appeal to the Court of Appeals. Mm-hmm. So in this state, let's say you're in Cape County, you're going to the Eastern District. If you're in Scott County, you're going to the Southern District. And there are jurisdictional boundaries that will affect which district you go to, right? Well, once you get on appeal, they have an opportunity again to bring up any error that they brought up below to try to tell the Court of Appeals, you know what, notwithstanding this judgment that was entered in their favor, the jury agreeing with them, we should be the ones who should win, and here are all our reasons. And this is a scenario where on appeal, a defendant usually gets a lot of room to argue. Mm-hmm. We file legal documents that are 40, 50, sometimes 60 pages long. They can be intricate, and they are just letting loose and trying as hard as they can to take a judgment away from somebody.
Yeah, and the initial appeal is a 3-judge panel. Whoever loses has the right to then ask the entire Eastern District or Southern District to hear the case, but I guess they call it en banc. Do I have that sort of right?
Yes, en banc.
En banc.
En banc.
No. Yes, I don't drink tea. So and that would be the entire Court of Appeals hearing it. If they lose there, then it goes up to your old stomping grounds, the Supreme Court.
Yeah. So the procedure there, exactly as Matt just said. You get your 3-judge panel. That's the first kind of round on an appeal. And like Matt brought up, they can move for rehearing en banc. They can say, hey, this is important enough for the whole court. They can get shot down again, or maybe they win. Who knows? But then if they lose, they have to try to petition to the Supreme Court. And the court, depending on the type of case, may be required to take it. And in some instances, they might have the discretion to take it. So again, even if you win on appeal, in some cases, that first intermediate appellate level may spell the end of the case, but there is still that option. They can take another crack at it. And even if they lose on appeal in front of the Supreme Court, they can again move for rehearing after that.
There are a lot of guardrails out there where courts have opportunities to dispose of frivolous lawsuits. We're going to talk about the one everybody knows about next week, the McDonald's hot coffee case. You are not going to believe the actual facts of that case. What you don't know about that case will fill an entire half hour. You've been listening to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. For Matt Glenn and Matt Davis, thanks for joining us. We'll see you in 1 week.
You've been listening to Tell Me I Have a Case with Dan Grimm and Matt Glenn. If you have questions and need answers, contact Cook, Barquette, Ponder, and Wolves today. Just go to cbpw-law.com. See you next week for Tell Me I Have a Case. The choice of a lawyer is an important decision and shouldn't be based solely on advertisements.